back to Winning Isn't Easy. In this session, we're going to talk about general questions involving step 5 of the 5-step sequential evaluation, the use of state agency doctors, the impact of drug addiction, and those kinds of issues, which I think also have some bearing on a Social Security disability claim. Now, at step 5, the Social Security Administration takes a 2-part approach to determining whether there's other work that you could potentially do in view of the mythical, hypothetical, not real-world national economy, in view of your age, education, work, experience, and residual functional capacity. Where this analysis takes or starts, if you will, is to determine the level of the work activities that you can do despite your physical or mental impairment. So in other words, how long can you sit, stand, stoop, walk? Do you have to alternate sitting or standing? Do you have problems with bilateral manual dexterity? Would you be off task? If so, how much? Would you be absent from the workplace? Do you have psychiatric problems that would interfere with your ability to do simple, routine, repetitive tasks, accept criticism, deal with changes in the workplace, interact with the public, coworkers, supervisors, or even stay on task? Now, at steps 4 and 5, past work, other work, the Social Security Administration will determine the residual functional capacity. If they determine at step 4 that you can't do the simplest and lightest job you held in the 15 years before you became disabled, they're going to move on, most likely, to step 5. Now, remember the analogy here that step 4 is much like the own occupation test, if you will, in an ERISA disability claim. Can you do the material and substantial duties of your occupation? There is a bit of a difference here in that Social Security is looking at jobs, the disability carrier is looking at occupations. Now, if the Social Security Administration gets to step 5, there are 2 ways that they're going to analyze the claim. If you are over age 50, they're going to use the medical and vocational grids. And to be disabled, to meet the grids, you have to have the right combination of your age, education, transferable skills, and functional capacities. If you're over 50, they're going to say, okay, what is your level of residual functional capacity? Is it medium, light, sedentary? And literally, there is a chart that you can look down to see what the answer is. And as part of this, the Social Security Administration is going to look at your past work to determine whether it's unskilled, semi-skilled, or skilled, because that's going to impact whether your skills transfer to other occupations in view of your residual functional capacity. This is very, very similar to what an ERISA disability carrier does, in that they'll determine your residual functional capacity, determine what skills you have from your prior occupation, and whether or not they transfer. Age is not a factor in an ERISA disability claim unless the policy or plan specifically says that it is. And there are many union plans that do require a favorable Social Security decision, and potentially in the context of that decision, your age is being considered. But for the most part, age is not a factor. Now, the use of the grids can be complicated, but if you don't, quote unquote, grid out, then the Social Security Administration is going to determine, again, whether you have skills potentially that would transfer to other work, or depending on that particular issue, whether, because that goes to the grids, what is your residual functional capacity, and are there other jobs that you could be plugged into that you don't want to do that doesn't pay a living wage? But again, what's key here in the similarities is that both Social Security and the disability carriers determining the level of your residual functional capacity. Potentially, they are trying to determine whether or not you have transferable skills. And in both instances, the game is sedentary work. If you can do sedentary work in the context of your ERISA claim, most likely your claim is going to be denied. In the context of a Social Security case, if you can do sedentary work, in part depending on your age, then you may win that case. The goal really is to prove, in both instances, in my view, is that you can't do sedentary work based on limitations on sitting, the need to alternate sitting and standing, concentration and pace, issues, bilateral manual dexterity issues, and attendance issues. I'm going to talk about how we kind of create this scenario in both instances because the techniques are the same, in my view, in both an ERISA disability and Social Security case. Okay, now let's talk about drug addiction and alcoholism. The Social Security regulations prohibit the payment of Social Security benefits if the person is disabled because of drug addiction or alcoholism. And the question often becomes, if they were to stop using drugs or alcohol, would they still be disabled? And if that's the case, then potentially you're entitled to your benefits. But if the drug addiction and alcoholism is material, no benefits are payable. Let me give you an example. Let's say you have epilepsy that's caused by the excessive use of alcohol, and your medical records establish that you are seen in the emergency room with you're being intoxicated and having seizures. Your medical records document the ongoing alcohol use. There's a clear opinion in the medical records that from your physician, that the epilepsy is secondary to alcohol use. Well, would benefits be payable? In the context of a Social Security case, if you stop drinking and your seizures stop, Social Security would find that the alcoholism was not material, even though alcohol abuse caused the seizures to begin with. On the other hand, if you continue to drink and your seizures continue, Social Security is going to find that your alcoholism is material and substantial and deny benefits. That same analysis holds true for drug addiction. Now, how does that apply or play out in the context of an ERISA case? I think that it's pretty similar because many disability policies or plans will have a limit on how long they will pay for disability insurance benefits that are caused or contributed to because of alcoholism. And of course, they also have provisions in the policy that limit mental nervous conditions to just 2 years. So many times the carrier will say, hey, this person's issues with drugs or medication or alcohol or the combination thereof really is the manifestation of a psychiatric condition. So we're going to get you coming and going. You're limited to 2 years under the mental nervous policy limitation, and you're limited to 2 years under our alcohol or drug addiction issues. This also can, by the way, raise its head in the context of a pre-existing condition clause. Depending on when you get the policy, there are pre-existing condition clauses, and there's a look-back period. So let's say you got your policy today, and the policy says, look, if you got treatment for or diagnosed with, even there's a thought that you might have a drug issue or an addiction issue, and you got that in whatever the specific period of time is, be it 90 days, 120 days, a year, the disability carrier will be looking in your medical records for a reason to deny a claim. And if they see that drug abuse or addiction is an issue, and that's the cause of your current claim, they will deny that claim flat out on the basis that the condition, the disability, is occasioned by a pre-existing condition. So you can see that that kind of plays out in both worlds. Why does a state agency Social Security doctor opinion is important? Why can it make or break your Social Security claim? When you apply for your Social Security disability benefits, the Social Security Administration is going to process the application at a local field office called Disability Determination Services, and they're going to verify the non-medical eligibility requirements. So are you insured? Are you still working? Are you making more than you're allowed to make to legitimately claim disability benefits? But the field office will then, once they've satisfied those questions, send your case to the DDS office, who is responsible for developing the medical evidence and making the initial determination as to whether or not you're disabled. Now, DDS will normally get your medical records, not always, and not always the complete chart. If the evidence is unavailable or is insufficient for them to make a decision, DDS will consult with a state agency doctor. These doctors, who are not specialists, will render an opinion about the medical or psychological issues in your claim. They're going to address things like the existence and severity of your impairment, the existence and severity of your symptoms, whether your impairment meets a listing or equals a listing, what your residual functional capacities are, notwithstanding your disability, whether the impairment meets the 12-month duration requirement, whether you fail to follow a prescribed treatment and that's failure's impact on your disability. In the case of drug or alcohol addiction, whether the addiction is material. Now, that sounds very similar in some respects to what a peer review doctor does in the context of a ERISA disability claim. Generally, the carrier will have a nurse review it, who is, an expert in nothing. And sometimes they'll actually have a peer review doctor who may not even be an expert in your area of disability. But they will be asked to address, what's the diagnosis? Is there an objective basis of the diagnosis? Is there an objective basis for the restrictions and limitations? What do you think the restrictions and limitations are? Is the patient compliant? If they were compliant, will they still be disabled? If their treatment is being recommended, is it consistent with complaints of pain or the level of disability or restrictions being claimed? And so we have liar for hire doctors, if you will, in both the Social Security disability world and in the ERISA disability world. So the analysis is one that flows in both of these cases. Now, why is this important? Well, if a Social Security claim was filed on or after March 27, 2017, there's no longer a treating physician rule. There's no deference, if you will, given to the treating physician. And much like in the ERISA world, the United States Supreme Court has said there's no treating physician rule. Now, I will tell you, DDS, much like disability insurance carriers, will defer to the state agency or peer review doctors at most stages of the case, because it's just easier to deny a claim relying on your own experts than actually have to look at the file and make a reasoned decision. Now, of course, the difference in this is both in the context of a Social Security case and an ERISA case, the peer review doctor never has a chance to examine you. They're just doing a paper review. And they are relying on diagnostic studies. They're relying on the reports of the physicians regarding the findings and exam findings. Similarly, the same thing happens with the peer review doctors, but sometimes they get more, like information from the employer. They may get surveillance film. So a copy of your statements, summaries of statements. So they're going to have a greater wealth of information, but the game is really the same. Now, under the Social Security regulations, the DDS claims examiner is supposed to provide a written analysis of the persuasiveness of the medical opinions they rely on or in denying the claim. They're supposed to consider the supportability and consistency in addressing the treating physician's opinions and the state agency consultative opinions. But they're not required to explain how they considered other factors, including the relationship with the patient, specialization, familiarity with the evidence, whether there's new evidence that's been received after the medical source statement opinion that they've had an opportunity to look at. I will tell you, under the ERISA scenario, there are ERISA regulations which do require that the disability carrier explain how they arrived at the decision and how they differentiated between the treating physician's opinions and their peer review physicians and why they're accepting one over the other. But notwithstanding those regulations, disability carriers don't always do that or don't fully comply with the ERISA regulations, which can potentially be the basis for a claims appeal of a wrongfully denied or terminated claim. Now, when we get a Social Security disability claim and we get access to the electronic file, we want to review it from beginning to end. And we specifically want to look at the state agency physician's opinion and the DDS analysis. Similarly, in the context of an ERISA case, we're doing the same thing. When we get the claims file, we're reading it cover to cover. We're looking at the adjusting notes to see what the claims examiner had to say, why they wanted the evaluation. We look at the peer review report to see who they are, what's their reputation, what questions were they asked? Were they asked the right questions? What was their answer? Was there any reasoning, in quotes, behind this answer? How does it compare or contrast to what the treating physician had to say? So you can see that these games are played both in the context of an ERISA disability claim and in a Social Security claim. These are some of the reasons why a DDS medical consultant opinion can make or break your Social Security claim. And sometimes I have seen the ERISA disability carrier seize on DDS state consulting reports as a justification for their denial. And yes, they can get your Social Security file. All right, let's take a break before we go on to questions, a series of questions in our third segment.